Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Let's take a realistic look, at the chances for reversal on appeal in the Murdaugh case. Let's head on down to the beach and talk about that. So I want to start with a little bit of a disclaimer because it keeps coming up in the videos, and I suspect I need to do this fairly frequently with folks. I have strabismus. Strabismus is an eye condition that is caused by prematurity. I was born premature in 1955. 5 doctors told my mom I wouldn't make it. 1 doctor believed that I would, and he turned out to be right. Strabismus causes me to be what's called a monofixator, which means I can look with this eye or I can look with this eye, but I can't look with both eyes at the same time because my eyes just don't work that way. So while it may appear that this eye is over here doing its own thing and I'm not looking at the camera, the fact is I'm looking at the camera with this eye, and that's really the only eye I can look at it with. Now, if any of you have made a comment about this and now suddenly you feel bad, I don't want you to, because everybody who's made a comment about this has been trying to be helpful, trying to make the video better. And this is just something I can't do anything about. And you know, when you have something you can't do anything about, you just make the best you can with it. And that's one of the reasons why things like racism and sexism, discriminating against somebody because of something they have no control over, is such a pernicious kind of evil. So with that little bit of a disclaimer, let's go into the chances on appeal here. If you go and Google chances of reversal on appeal in a criminal case, what you'll find is that in the United States federal courts, your chances of reversal on appeal vary from circuit to circuit. The average is 8.6%, but for example, in the 10th Circuit, it's around 4%. In the 9th Circuit, it's higher than that. And in the 2nd Circuit, it's about 9%. So in federal appeals, of which this is not one, you have, if you want to be just kind of ballpark, it's 1 in 10. 1 in 10 chance of being reversed. And then this little chart here shows an interesting comparison in state courts. In state courts, only 63% of appeals are reviewed on the merits. Now let me explain what they mean by reviewed on the merits. In pretty much every state, you have a state court of appeals that handles most criminal cases. The state criminal court of appeals takes the appeal directly from the trial court. You have an absolute right to appeal to the court of appeals. If the court of appeals rules against you, in most states, you only have an option to request that the Supreme Court review your case. In South Carolina, that's done by a writ of certiorari. And for example, in Missouri, it's done by what's called an application for transfer. But either way, the court doesn't have to review your case on its merits. It can take a look and say, the Court of Appeals got this right. And for example, in Missouri, what they usually do is they look at whether or not the law was stated correctly and whether it was applied correctly. And if it was, then they're not going to take review on that particular case. And I think that's probably true for most of the courts of appeal and Supreme Courts in most of the states. Now, in going through some of the opinions on the South Carolina judicial system, it would appear that the rate of reversal in murder cases is slightly higher than it is for general criminal cases. I think it's probably up around 9%. But again, this is still the equivalent of trying to push a boulder uphill with your nose. It's a long, hard slog, and the odds are stacked against you. But that doesn't mean you can't be successful, and that's particularly true when you have a lot of money to throw at the particular problem. One of the things that's interesting about South Carolina courts is that everything is pretty much reviewed under an abuse of discretion standard. In other words, if the trial court admits evidence, it's subject only to abuse of discretion. And abuse of discretion means that either they did not follow the correct legal rule, they didn't state the correct legal rule, or they didn't properly apply the legal rule. Again, abuse of discretion is a very forgiving standard for the trial courts. And the reason that's there is because the trial court is there. He's heard the evidence. He's seen the evidence come in. He knows both what the state and the defense are trying to accomplish. And he is in the best position to listen to the proffers of the testimony and give a ruling based on what the people are telling him. And here's the way South Carolina law refers to that. In criminal cases, an appellate court sits to review only errors of law, and it is bound by the trial court's factual findings unless the findings are clearly erroneous. The admission of or exclusion of evidence is left to the sound discretion of the trial judge, whose decision will not be reversed on appeal absent an abuse of discretion. An abuse of discretion occurs when the trial court's ruling is based on an error of law or when grounded in factual conclusions is without evidentiary support. I think the primary focus of Murdaugh's appeal is going to be on the admission of the other crimes evidence. And so I wanted to take a look at some of the recent cases that have dealt with this issue. There are 3 cases that came out in 2020, Durant, Cotton, and Perry, that all deal with Rule 404B, the rule that the defense tried to keep the prior crimes or the other crimes evidence out with. And Durant and Cotton were affirmed. The use of the other crimes evidence was affirmed by the state Supreme Court. And in Perry, it was reversed. And in that case, the reason it was reversed is because it was simply too remote in time, about 20 years prior. And so it didn't really have a logical nexus to the crime at issue there. And you can find these opinions online, Durant, Cotton, and Perry, on the South Carolina judicial site if you want to read them. But fortunately, the judge in this case made it so that you don't need to do that. He issued his own order, a written order about the admission of other crimes evidence, which I find to be somewhat unusual. We don't really see trial courts in Missouri do this too often on criminal cases, but here, Judge Clifton Newman did a separate order detailing the reasons why he was admitting this other crimes evidence. Let's take a look at that. So Judge Newman tells us why we're having this order written, and then he goes in to explain some things that probably were not real obvious to the public at large. That being that the court held an in-camera hearing over the course of several days during the 2nd and 3rd week of the trial. After hearing the testimony of numerous witnesses and reviewing the exhibits submitted, as well as considering the totality of the evidence presented thus far during trial, the court, as set forth herein, hereby grants the motion. So Judge Newman is not burying the lead here. He's telling you right up front, look, we're going to get this evidence in, and I'm going to lay out below every reason why I think it needs to come in. And some of those reasons are pretty doggone good when you get right down to it. So the first thing the court does is it very clearly lays out what is required in order to get this evidence in. Evidence of other crimes, wrongs, or acts is not admissible to prove the character of a person in order to show conformity therewith, action in conformity therewith. An exception exists, however, when the evidence offered to show motive, identity, the existence of a common scheme or plan, the absence of mistake or accident, or intent. And then later he says, evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence is what defines relevance. And in this case, he found relevance fairly easily. Judge Newman then goes on to say, after determining relevance, the court must determine if the evidence falls within an exception to the rule. And the court notes that the evidence of other crimes must be proven by clear and convincing evidence, and the court is required to conduct a Rule 403 analysis. Now, a Rule 403 analysis is traditionally what South Carolina courts refer to as a balancing test. Essentially, it balances the relevance and the usefulness of the material on behalf of the state against the chance that it might suggest an unfair or improper basis for a ruling against the defendant because he is, quote unquote, a bad person or has a propensity to commit crime. Well, it's up to the state to tell the judge why it wants to introduce this evidence. And so here's what the judge says about the state's contentions. First, he notes that it's a murder case, and then according to the state, the nexus is supported by the unusual circumstances of the murders, that the defendant was the last person to see his wife and son alive, and the one who discovered their bodies in a relatively short period of time. During the in-camera hearing, which, by the way, means a hearing that was held in chambers and not out in open court, the state presented evidence of numerous financial crimes allegedly committed by the defendant. During the hearing, the state argued that the logical nexus between the alleged murders and the other crimes is that the looming exposure of financial crimes provides motive for the murders and is evidence of malice. That's important because they don't have to prove motive, and as a result, you really don't have to prove why the actual murders occurred, but you do have to prove malice. So what the judge is doing here is really insulating his decision against later appellate review, and he's doing it in a brilliant manner. He notes what clear and convincing evidence is. It leaves the finder of fact with a firm belief of the facts to be proven, and in this case, when he is determining whether to admit this evidence, he is the finder of fact. So only his opinion really matters on this, because the courts of appeal and the Supreme Court have to defer to his fact-finding because he was there, he heard the evidence. At the end, he goes through the evidence and all the witnesses, and he says, based on the overwhelming amount of evidence submitted for the purposes of this hearing, the court finds that the state has established the above by clear and convincing evidence. Which is not surprising, because there was a huge amount of evidence. In addition to the testimony of the witnesses, which was given in camera, there were all the documents and exhibits that laid this out very clearly and established exactly what Mr. Murdaugh was up to. Now here we have the court's findings, and remember, these are findings of fact which are insulated from appellate review unless they're clearly erroneous. The court has considered all the contentions of the state and finds that this evidence is relevant as it tends to support the contention of the state that defendant sought to divert attention from the looming exposure of theft, fraud, and deceit that he committed against his clients, friends, family, law firm, and business associates. Additionally, defendant introduced motive as an issue when he stated to law enforcement that he believed the murders were connected to the boat case. In other words, by suggesting that, either through counsel or on the stand, essentially what Murdaugh did is he opened the door to the admission of this evidence specifically as it related to motive. He made motive an issue, therefore he can't complain about evidence that's used to establish motive. Next, Judge Newman tells us that under the Rule 403, if the probative value of the evidence is substantially outweighed by the danger of unfair prejudice, then even if relevant, it can be excluded. The court finds the probative value is not substantially outweighed by the danger of unfair prejudice. He then notes that considering the totality of what has been presented, and since the identity of the perpetrator is disputed, the court finds the state is entitled to have the jury consider whether the apparent desperation of the defendant resulted in the commission of the crimes alleged. While motive is not a necessary element of the crime of murder, the state must prove malice, and evidence of motive may be used to prove it. Additionally, the identity of the perpetrator is a critical element that must be proven beyond a reasonable doubt, and evidence of motive may be used to meet that burden. The evidence of other crimes is admissible for non-propensity purposes and does not suggest to the jury that the defendant has a tendency to commit murder. And this is an important point. It's not being used for an improper purpose. If the issue was the financial crimes, it might be considered improper evidence. But here it goes to his ability to commit murder, and it doesn't have the tendency to show that he is a murderer. As people said all through the trial, they've proved he's a liar and they've proved he's a thief, but they haven't proved he's a murderer. Well, this goes to the liar and the thief part, not to the murderer part. And here Judge Newman surprises again because he goes back to something that a lot of us learn in law school in evidence class about res gestae, which is evidence of incidental facts that would otherwise be inadmissible in a trial as irrelevant or hearsay, but that is admitted because it helps explain and give context to more central evidentiary facts. And that's exactly what happened here. Judge Newman then goes on to tell us about the res gestae. He says the state alleges on June 7, 2021, defendant was under immense pressure after being confronted about missing fees, the upcoming hearing on the motion to compel his financial information, his dire financial straits, and the looming exposure of years of criminal activity, and that led to the murder of his wife and son. Our courts have held that where evidence of other crimes is an integral part of the crime for which the defendant is charged, or it is needed to aid the fact finder in understanding the context with which the crime was committed, then the evidence is admissible under the theory of res gestae, that's State versus King, a 1999 case. The court finds that the activities and conduct of the defendant on or about June 7, 2021 is admissible under res gestae. And then, although I didn't capture it here, he puts out an even bigger Easter egg. He says that because it's res gestae, he doesn't need to conduct a 403 balancing analysis, but he's done it anyway in the event that a later reviewing court determines that res gestae isn't proper, which I don't think is going to happen. So I think you can get to the issue of it being properly admissible for motive because there really was a gathering storm. And all of this financial crime information is res gestae. It's part of the entire story. In addition to that, you get there from the discretion of the trial judge who sat there and heard the case. So there's already a little bit of a bias in favor of the trial judge here. Okay, I have to admit that until I read Judge Newman's order, I was much more worried about the outcome of an appeal because I had not seen anywhere during the trial where the judge had conducted this Rule 403 analysis. And again, that's the probative value has to be substantially outweighed by the prejudicial effect. In other words, the relevance doesn't substantially have to outweigh the prejudicial effect. It is the prejudicial effect that has to outweigh the relevance. And no matter which way you look at that, it just doesn't fly in this particular instance. So I thought he did a really good job of laying out the facts that he relied upon to determine that the 403 rule, the 403 analysis favored the state. I also thought it was just brilliant. I had come up with the idea of res gestae on my own, but I was shocked to see it in the trial court order, primarily because that's not something you see a lot. And the use of res gestae is, I think in some ways it's kind of antiquated because it's much more rule-oriented now. But the common law, even in a situation where you have these rules of evidence, the common law still has a lot of impact. And that's what happened here. Given that situation, given all of this evidence that tends to illustrate the propriety of having put this evidence in, what are Alex Murdaugh's chances on appeal on the 404 issue? I'd give him less than 10%. I'm not sure exactly what that number would be, but I would say less than 10%. There was also a question about post-arrest silence, but he didn't actually engage in post-arrest silence. He talked to the investigators at the crime scene. He wasn't silent. And after he was arrested, the question that was asked did not implicate post-arrest silence. And there's absolutely no chance of that, I think, being used to overturn this conviction, either at the state Supreme Court or at the United States Supreme Court, or perhaps later on in a habeas corpus or other federal appeal. And there will be multiple appeals filed in this case. They'll still be appealing this 20 years from now because Alex Murdaugh will still be wanting to get out of jail. That's sort of what I have for you on the Murdaugh appeal chances. I think the 404 is probably still the best avenue they have to pursue, but one of the things that I think is really important here is that you had a really good trial judge with a sound understanding of the fundamentals of how you conduct a trial and full knowledge of exactly how much discretion the courts are going to give him, because he based his rulings on the facts, and the facts are not really subject to appellate review unless they're clearly erroneous. So that has to be a situation where the judge finds that the color is black and the evidence is that the color is white. There's just nothing like that in this opinion with regard to the admission of the financial crimes. So I look for this to be a fairly easy appeal for the state. As I mentioned earlier, I would just argue, look, we weren't trying to show that these financial crimes made him a murderer. We were trying to show that he was a liar and that they provided the motive for the murder and an element of malice. Because they do have to prove malice, and they don't have to prove motive, but I think they did. Now, again, I think there's probably some chance of being rebuked, although not reversed, for having placed such a heavy emphasis on the financial crimes. But again, you got to let lawyers try their case, and there were not continuing objections to that. The main objection was at the beginning about the admission of the financial crimes at all, and there was never any objection during the closing argument or during the cross-examination to a continuing emphasis on these financial crimes. I think that issue is waived, and waiver is always present in cases where you bring it before the appellate court. If you don't give the trial judge a chance to set the record straight and tell the state, hey, stop putting so much emphasis on this, then you've waived that right on appeal. And, you could ask for clear error, but reversal on the basis of clear error is rare. And I think it would be exceptionally rare here. So, again, I do think they have the job of pushing the boulder up the hill with their noses. This is not going to be an easy appeal to write. It's not going to be an easy appeal to win. I think the state has the better position on this. And I welcome your comments and questions on this issue, because I think it's an opportunity to teach a little bit about how my end of the law works, being somebody who does a lot of appeals. If you have any questions, leave them in the comments down below. Like, share, subscribe. A shout out to the Murdaugh Murders subreddit for putting my videos out there. I'm grateful to you for having done that. Thank you so much. And if you have an opportunity today to go out of your way to do something kind for somebody, maybe you just open up a little thing on the shopping cart and get it for somebody so they don't have to pull, strain their arm muscles trying to get it out of there. Any little thing you can do to make someone's life better is a win for all of us. Thanks for watching. Have a great day. I'll catch you on here next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.